front of us we see Tony. Tony has left Manukau District Court. And why did Tony leave Manukau District Court? Because we just won, case dismissed. Our Section 147 application for dismissal was accepted. So yeah, quite chuffed. Tony's pleased. It's all over and done with. So sweet ass. Hello. Good morning, everyone. I might look pleased with myself, but that's because I am. No, I don't like to come off as obnoxious. This is the update for Tony's $230 speeding ticket from Manukau. His defended hearing was today, the 12th of January 2023, and what I did last night was I drafted up an application for stay due to abusive process and Section 147 discharge. I'll put that up so you guys can have a look at how I've written it, but I basically state the facts. Now, you guys, if you've been following this, Tony got a ticket on the 27th of July last year for apparently doing for a $230 speeding ticket in Papatoetoe by a speed camera. So on the 12th of November, his first call hearing was set for the 25th of November originally. So on the 12th of November, 2 weeks roughly beforehand, I filed a memorandum to the Judicial Officer requesting copies of all documents in disclosure. And in that memorandum, I specifically list things entitled due to disclosure, such things as witness lists, brief of evidence, summary of facts, all the wonderful things that the Criminal Disclosure Act 2008 tells you you're entitled to as a defendant. Well, so we got the disclosure. It was according to the police's disclosure index. Disclosure was given to us on the 14th of October, although Tony didn't receive it until the 9th of November, because he received the disclosure for the speeding ticket the same day he was entering a plea of not guilty to the airport charge of trespass and disorderly behaviour and whatnot. So yeah, filed the memorandum for document on the 12th. On the 13th, we filed a notice of appearance. Now, if you go and look at the Criminal Procedure Act 2011, look at Section 38, which means for a Category 1 offence, you can file an appearance by way of notice, which is exactly what we did by filing a notice of appearance. So those documents were all filed on the 12th and 13th of November. Come the 25th of November, the court had industrial action, and it was his first call hearing where he had to enter a plea was then adjourned until the 8th of December. Now, because we only found out on the 5th of December, because no one told Tony it had been adjourned, if he didn't know, he wouldn't have shown up, and it was just because I was chasing them up for the next hearing date that we found out on the 5th of December that he had a court appearance on the 8th of December, and we were told that there may be a warrant for his arrest if he doesn't attend. So under threat of arrest, we showed up. Now, on the 8th of December, a not guilty plea was entered. At that time, we also pointed out to the judicial officers, the two JPs on the bench, that we had still not been supplied full disclosure. So then we just go ahead and have Christmas, New Year's. Okay, we waited from the 8th of December until the 12th of January, just over a month later, for the defendant hearing. And then today, before the defendant hearing, at 1:30 in the morning, because I spent 3 hours writing it for him, for Tony, and at 1:30 this morning, I sent via email to the Police Prosecution Service in Manukau District Court the application for stay and due to abusive process and Section 147 discharge, Section 147 of the Criminal Disclosure Act. And so me and Tony show up before 10:30, and you know, he gets called. I stand up with Tony next to him as the Mackenzie friend. The duty solicitor says, "Oh, this is Mackenzie friend." The JP said, "Well, it's Mackenzie friend, he can go and sit down." But just before I sat down, I made sure I handed a couple of copies to the duty solicitor, who then gave to the prosecution and to the JPs the document that I'd filed, the Section 147 dismissal charge. Now, the police could have 146'd it and withdrawn, but they didn't. What they did do is they stood up and I'd just like to point out that the Police Prosecution Service knew that I'd filed that before the duty solicitor handed them a copy, and they stood up and they said, "Yes, Your Honour, the police admit that we have failed in our duty of disclosure." So they admit they'd failed, because what they didn't supply, which is quite crucial, is a witness list. The witness list not being supplied meant that Tony had no idea there was going to be a witness. So that kind of breaches his section 24A and D of the Bill of Rights, where you're supposed to have fully informed of the course and nature of the proceedings, and you're also supposed to be given adequate time to mount a defence. Well, if you're not told until the day that there's a witness, it kind of makes it hard for the defence now, doesn't it? And remember what I was saying the other day on a recent video about, if you're a self-representing litigant, you can cross-examine a witness, but the court does not have to put any weight to that cross-examination, because you are not a member of the bar. So I put that in the document as well, pointing out that if the court chose to proceed, that would be an abuse of the process. It would be the court failing in its duty to assign counsel to assist the self-representing litigant in cross-examination, and that'd be that. You know, if they do that, then that would be a breach of natural justice under Section 27(1) of the Bill of Rights, and that we would seek redress in a higher jurisdiction or higher forum for a miscarriage of justice that would be created if the court chose to go ahead and not assign counsel and still go ahead with the hearing. It worked. So prosecution stood up, said that they had no objection to the Section 147 dismissal because they had failed in their duty of disclosure. The JP looked at Tony and says, "Oh well, we'll deal with that matter right now then. It's dismissed, you're free to go." And Tony's sort of like standing there wondering, what? I just looked at Tony and says, "Come on mate, let's get out of here. Just one." So yeah, great day. And now that that matter is completed, I will be releasing all of the documentation and showing you all. But it's pretty much in my legal templates for all folder, which is in the description of all of my videos. You'll see the requesting a hearing. You'll see the memorandum to a judicial officer for access to documents, and you'll see the notice of appearance. And very shortly, I will turn the application that I made today into a template for you all to have fun with as well. All I've basically done in the application was state in a chronological order what had happened for the grounds. That we requested documents, that we filed a notice of proceedings, that it was adjourned and we weren't informed of it, and that we still hadn't received a witness list up until the date of the defendant hearing. They did not have a pot to piss in. So there you go guys, that's the update. Tony was wrapped as, and we shall see how his second speeding ticket on the 23rd of January in Hamilton goes, because I wonder if they've forgotten to supply Tony something. Anyway, we'll leave it with that. Catch up with you later. I'm heading home. Tony's chuffed, I'm chuffed. The world's a better place. And Tony didn't have to pay $230 speeding ticket because it's only an allegation. The fact that you guys all pay your speeding tickets means you're accepting it. You're not defending or maintaining your presumption of innocence. And if they're going to drag you through a criminal court case, that's how you win. Alright guys, my own speeding ticket is on the 27th of January at Waitakere. That's a slightly different matter. It's not a speed camera. Allegedly was pulled over. Yeah, there's other ways to handle that one, and I'll let you all know how that gets on after it happens. It's, you know, while a matter is before the court, you're not allowed to really disclose any major details or anything that's going on. It could prejudice the case. So yeah, this is why I'm telling you about Tony's. But yeah, there's another ticket to come, and as far as his Auckland airport thing is concerned, again, I wonder what the New Zealand police have failed to give Tony. May or may not have something to do with witness lists, and as far as that one's concerned, I don't care if they know they've failed to give him his witness list on that one, because on the 9th of November, because I asked the judge made a section 30 order for the prosecution to supply full disclosure within 30 days, which meant by the 9th of December Tony had to be supplied full disclosure. And he did receive a rather large bundle of disclosure on the 12th of December. You're allowed 3 days for postage. But what was missing? The witness list. And now that they haven't supplied it by that time, they are in breach of that order if they try and supply it after the fact. On the 9th of November, the prosecution didn't even know how many fucking witnesses they had. But they had 30 days to get it sorted out, and guess what they fucked up? No witness list. So his call-over hearing is, I think, 25th of May for that one, where basically they just want us to show up to make a date for the actual hearing. He does have the ability to not have a judge-alone trial and have a jury trial, but we're going to see what we can file prior to that and see if something gets dismissed. Because I tell you what, if the police admit they failed their duty of disclosure for a speeding ticket, they can bloody well admit that they failed their duty to meet the court order of giving full disclosure by the 9th of December, and now that time has passed. Even if I chased them up for it, which I'm not going to, I'm not going to hit them up and say, hey, you forgot to give us this, and point out their failures just so they can give us it and try and counter. No. Now that because that section 30 order was made, they are then in breach of that court order. So they better dismiss the charges, hadn't they? So I'm going to be writing a few more dismissal documents for a few more court cases, and file it ahead of time, because like I say, as far as the airport incident's concerned, that section 30 order gave them a D-date as to when we were supposed to be supplied shit. After the hearing for the speeding ticket, we decided to pop on down to the registry this morning, because they don't like responding to my emails, because I've been emailing them now chasing the a copy of the section 30 order, so I can incorporate that into my dismissal application. And I was told at the registry that they will be emailing, it's going before a judge, and they will be emailing that to me in the next couple of days. And just to be thorough, I also put a request in for a full transcript, not just the transcript, a full transcript of that hearing on the 9th of November, in case they want to turn around and say, no, the judge never made a Section 30 order, because it's in the fucking transcript. See how we go, guys. Much love to yous. Enough of my babble, and I'll concentrate on this shit weather and driving. Bye. Take that, fucking New Zealand police.